Today before Judge Vincent Collada, we have a very sad case. This defendant has been convicted of killing his wife in the heat of rage, and is here to be sentenced for that act. Pay particular attention to the details of this case as laid out by the prosecution. The defendant is facing up to life in prison, so let's see how Judge Collada dispenses justice for the family.
On April 12th. Mr. Dorner is a 53-year-old man with no prior acts of violence against anyone. He has some medical issues. He had a heart attack and a stent inserted back in 2013. This led to the discovery of an aneurysm, and within 3 months of that, he had to have surgery to correct that. Mr. Dorner is also OCD, and he suffers from depression. Currently, while incarcerated, he's receiving medication for his depression. Now, what happened on April 12th, Your Honor, is completely out of character for Mr. Dorner, even with the depression issues he suffers from. Never in a million years did Mr. Dorner think he'd be capable of doing such a heinous act against somebody, especially against somebody that he loves so dearly. Mr. Dorner met the victim, Ms. Debbie Moore, back in 2021 at a campground. They both shared a hobby of camping, and they soon began dating thereafter. During the last 9 months of their relationship, they lived together at Debbie's residence here in Concord. As with most relationships, Your Honor, they had their ups and downs, they had their arguments. Mainly, those stemmed from jealousy that each other had with regards to their respective past relationships. But Mr. Dorner loved Debbie very much. One of the other issues that caused arguments between them was the amount of time that Mr. Dorner spent taking care of his two children. During his marriage to his ex-wife, and even after their divorce, Mr. Dorner was the primary caregiver for his two children, who are now, they're still minors, but they're now teenagers, with regards to taking them to their various school activities, sports, things like that. And this took time away from his relationship with the victim. As such, they argued, but they always made up, and nothing ever rose to the level that it did on April 12th. They had been planning a trip together to Florida for quite some time, and on the morning of April 12th, Mr. Dorner was especially depressed because for the past couple of weeks they had been arguing more than they normally did. And that morning, they were having breakfast together when Debbie told Mr. Dorner that she had had enough, that she didn't want to deal with this anymore, and that she didn't want him to go on the trip to Florida. Now, Mr. Dorner didn't take this necessarily as a complete breakup, but he did snap when he heard this. And then he committed this horrific act. Mr. Dorner has stated that if there's any way he could take back what he did, he would do it. He simply cannot believe what he did. He paced around the house after this happened, Your Honor, for a couple of hours, and he decided that he was going to end his own life. He ended up texting his two children. He told them that he loved them very much. With regards to his son, he informed his son of some property that he had that he wanted him to have. And then Mr. Dorner proceeded to stab himself. He stabbed himself in the neck, in the arms, he slit his wrists, and then he crawled out into the garage where he intended to die. His children were quite alarmed at the text they just received from their dad, so they went ahead and informed their mother, his ex-wife, Carol Lee. She's a registered nurse, but she immediately went over to Debbie's house where she discovered Mr. Dorner in the garage, and Mr. Dorner then proceeded to tell his ex-wife what he had done. She ended up calling 911. I know that nothing, Your Honor, no words, no punishment, can ever bring back Ms. Moore to her children and her family. Mr. Dorner has accepted responsibility for his actions that day, and he is extremely remorseful for what he has done. Mr. Dorner has never exhibited any type of violent behavior in the past, and this was completely out of character for him. This court has a lot of discretion as to what it can do at sentencing this morning. We are asking this court to consider Mr. Dorner's conduct through his life too, not just on what happened on April 12th. We are asking this court to consider Mr. Dorner's age and his health conditions. We are asking this court to consider the fact that Mr. Dorner has taken full responsibility for his actions and that he is extremely remorseful. With regards to sentencing, Your Honor, we are asking this court to consider a life sentence with the possibility of parole after 20 years. Thank you, Your Honor.
Thank you. Mr. Dorner, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say at this time?
You are a sick, evil person. You are going to rot in prison all your life. And I hope you live to be 100 years old. It is impossible to explain to this court how much hurt you have caused to my family, to friends, and me. I'm a walking zombie now. I'm lost. I'm empty. I fight every day to get up and go to the bathroom. I don't want to do nothing. I sleep 16 hours a day. He took my life too. You are going to hell on earth in prison. I hope you enjoy living with sick, evil murderers, rapists you should get along great with. You are the worst example for your children as a father figure. You are going to be raped and beat up many times till you die. And when you die, you then get to go see your father, the devil. I'm glad you didn't die when you cut your wrist. I want you to suffer in prison. Then, vengeance is mine, saith the Lord. Enjoy your new home and your many boyfriends while you're in there. Honorable Judge, I beg you not to let him see daylight again. I ask you for the maximum sentence. He committed the worst crime just about on this planet. And his sorry means absolutely nothing. You loved your kids, and you still did this to them. Your sorries and your love and all this, it's all meaningless. You're a nothing, nobody, loser, evil son of a bitch. And I also would like to ask if he could be put on lockdown one day or 2 times a year so he can lay in there and think about it.
Thank you.
Thank you.
Mr. Gretzky, on behalf of the state.
This court is very familiar with the facts of this case, been outlined at the change of plea by multiple people and in the PSR in detail. Whatever the nature of the conversation that precipitated the defendant's decision, he made a decision to kill the victim. The victim went down the hallway of the home to the bathroom, to the bedroom. The defendant waited in the kitchen, then came into the bedroom, followed her, strangled her first from behind till she went limp, and then strangled her with both of his bare hands until she died. This was a completely senseless crime. There's no reason, no rationale that can put what happened here into a lens that makes sense. Not one reason that has been given. Not the telling him that he couldn't go on a trip, not having an argument about the amount of time that he's able to spend with her, not financial strain, not familial obligations. Not one of these factors puts this crime into a perspective that makes any sense. The victim, as has been stated, did not and could not have seen this coming. In the evidence, there were text messages, evidence of instances where the defendant and the victim had previously said to each other that the relationship was over. This was a strained relationship at times. There were texts where the defendant would tell the victim it was over, the victim would tell the defendant it was over, but they stayed together. So when the victim brought up issues about the relationship to him on that day, that was not a shock to him. There was nothing about bringing up those issues that would have led the victim to believe that she was in harm's way. There was nothing about the defendant's previous behaviors that could have led her to think that she was in the way of danger. She had no reason to think her life was in danger. Yet the defendant had made a decision to kill her. I do not agree with the notion that this was a snap decision. Again, there was that time while the defendant was in the kitchen and the victim was in the bathroom and then the bedroom. There was so much time while he was attacking her. This murder was not committed with a gunshot or with a stab wound. One pull of a trigger, one stab. Those are actions that take a second, that can be lethal, that can be irrevocable, in just a second. This murder was committed over numerous minutes. He strangled her in multiple positions for those minutes. Court is aware of the great number of strangulation cases that occur and the harm that occurs from them, even serious physical harm. But to cause death through strangulation takes time. A snap decision could have stopped his conduct, but the conduct itself was not a snap decision. He could have prevented her death if he had just stopped. But he continued, focused on his intention to kill her for all of those minutes. Finally, Your Honor, it has been said that this is out of character for the defendant. Character can be defined as one of the attributes or features that make up and distinguish an individual. Character can also be the aggregate of distinctive qualities of an individual. The defendant is not a young man. He's not susceptible to the impulsiveness of young men. Nor is he a man who has lived a life that doesn't understand the greater repercussions of one's actions on others, or the compounding impact that death has. Taking responsibility and perhaps even regret may be in his character, but this senseless violence, this murder, is also his character. Capability of doing this has been mentioned. All are capable of doing this. He murdered her with his bare hands, but all do not do this. This is the defendant's character. It is one of the attributes he carries. It is part of the aggregate of the qualities that make up who he is. There's no amount of time, no amount of law-abiding years that negate such a violent, cruel act as the one that he committed, no matter at what point in life that act is committed. Therefore, the state is asking the court to sentence the defendant to life in prison with the possibility of parole after 25 years.
Thank you. Well, this court has reviewed the pre-sentence report and investigation. I have considered the victim impact statements that have been received by the court. Read them all. I've considered the defendant's sentencing memorandum that was filed. Received a couple letters on behalf of the defendant. I've read those as well. I have considered everything that's been said here in court today by Mr. Watson, the defendant himself, the prosecutor, and all the family members that are here and spoke on behalf of Ms. Moore. I've considered the facts and circumstances of the offense involved, the nature of the offense, the nature of the conduct. All this is considered by this court in light of the purposes and principles of felony sentencing, which are set forth in 29 and 2911 of our Ohio Revised Code. As for the factors in 29, 2912, factors indicating the conduct is more or less serious, the court does note that the defendant's relationship with the victim facilitated the offense. This was someone he supposedly loved, was in a relationship with, lived with her. Relationship facilitated this offense. The victim herself obviously suffered serious physical harm, but in these types of cases, there's more than one victim. Family members are also victims, and they have suffered serious psychological harm as a result of the defendant's conduct, and that makes it more serious. Other relevant factors indicating it's more serious is the very nature of the conduct itself. The circumstances surrounding how this murder occurred. As the prosecutor alluded to, this is the first strangulation, suffocation case I've ever had. I've been doing this for 34 years. Most murders involve a weapon, firearm. The prosecutor alluded to this as well. But those cases, it's horrible, obviously. I'm not trying to minimize those types of cases one bit. And using a firearm is certainly very serious. In fact, we have laws that make it more serious because firearms are used. But as the prosecutor said, those are split-second decisions that are made. You pull the trigger, you can't put the bullet back in the chain, you can't put the bullet back. This case, though, he engaged in the conduct and started, and he could have put it back. He could have pulled it back. He could have stopped at any time. This took a period of time in order for him to accomplish what he intended to accomplish. So some split-second decision where you lost your cool, whatever the case may be. In other cases, you stab someone, you pull the trigger, you can't do anything about it after that. You could have. You could have stopped. You could have stopped at multiple points. But you didn't. You kept on going. You kept on going until you accomplished your objective. And you did nothing. Did nothing after that in regards to her. You didn't call for help. You didn't call 911. Who knows what they could have done? But their intervention would have interfered with what your objective was, which was to kill her. And the nature in which you did it, and the circumstances surrounding it, make it more serious than what we normally deal with in these circumstances. No factors indicating the conduct is less serious than normal. As for recidivism factors, you're sorry, yes, you're sorry, and you accepted responsibility for committing the actual physical act that resulted in Ms. Moore's death. In regards to your explanation, it's not very clear. You told multiple people when this happened that you did it because she broke up with you. But you made it abundantly clear to the probation department that she didn't break up with you. Well, why'd you do it? What led you to do this if it wasn't because she was ending the relationship? But you, for whatever reason, wouldn't acknowledge that to the probation department. You never offered an explanation to the probation department, so why'd you do it? You offered no explanation. In fact, you made it clear that it wasn't because she didn't break up with you, though you told everybody that day. Told your ex-wife when you called on the phone, when she showed up, told our police officers. I think you even went to the hospital, maybe, if I'm remembering correctly. Maybe I'm wrong on that. But you won't admit to that now. As for factors indicating recidivism is less likely, the court does note the defendant doesn't have any prior history. I think he has got a misdemeanor conviction from 20 years ago, perhaps. That's it. And I will note that that's extremely rare. People that are sitting in that chair usually have a history. So he has led a law-abiding life, which is one of the factors I'm required to consider for a significant number of years, basically his entire life. This offense carries with it mandatory prison term. Prison is certainly consistent with the purposes and principles of sentencing. I'm not even able to consider community control sanctions, but then it's not amenable. Therefore, to be the sentence of this court that in count 1, in charge of aggravated murder, defendant serve a term of life in prison with parole eligibility after serving 30 full years of imprisonment. You get credit for 223 days you've already served. The rest of the indictment is hereby dismissed. In regards to the request from the victims to have them serve holiday, or not holidays, but anniversaries, whatever, I'm not allowed to do that. I have no authority to do that. I've done it before, quite frankly, and have been rejected and told I can't do it. So I'm not permitted to do that. You're ordered to pay all costs incurred in this action. You're ordered to register, as I told you initially, as a violent offender. In regards to the restitution requests, I have read all of those, and again, the law does not allow me to order restitution for in the specific reasons that restitution was requested. These types of cases, I can order funeral bills or funeral expenses. That wasn't requested at all. The other items and reasons for restitution, I don't have the authority to do that. I think that covers everything for the record. Mr. Gretzky, is there anything else I've omitted or need to address?
No, Your Honor.
Mr. Watson or Ms. Clapp?
No, Your Honor.
All right. We're adjourned.
Cloaked in folds of midnight waters, side by side, we sons and daughters, we set forth for no king's